This week in U.S. immigration news, we are going to cover USCIS welcomed 19,000 new citizens, EB-1 and EB-2 form I-140 petitions, young immigrants start businesses to get ahead, migrants filed class action lawsuit against DeSantis, D.C. Council approves new office to aid migrants, final rule to restore asylum regulations. USCIS has welcomed 19,000 new citizens in more than 235 naturalization ceremonies across the country between September 17 and September 23 to celebrate Constitution Day and Citizenship Day. USCIS reaffirms its commitment to promoting citizenship and making the naturalization process accessible to those who are eligible. Along with the naturalization ceremonies, USCIS will also host numerous activities throughout the month of September to empower immigrants to pursue citizenship along with the rights and opportunities that accompany it. USCIS is implementing the next phase of premium processing expansion for certain petitioners who have a pending Form I-140, immigrant petition for alien workers, under the EB-1 and EB-2 classifications. This phase applies to certain previously filed Form I-140 petitions under an E-13 multinational executive and manager classification or E-21 classification as a member of professions with advanced degrees or exceptional ability seeking a national interest waiver. Those wishing to request a premium processing upgrade must file Form I-907, Request for Premium Processing Service. Starting September 15, 2022, USCIS will accept Form I-907 requests for E-13 multinational executive and manager petitions received before January 1, 2022 and E-21 NIW petitions received on or before February 1, 2022. There are an estimated 820,000 entrepreneurs in the U.S. without legal status, an increase compared to 2016 with 770,000 immigrant entrepreneurs. The growth has been influenced by younger immigrants, explained Ileana Perez, Director of Research and Entrepreneurship at the advocacy organization known as Immigrants Rising. Perez explained she first began to notice younger immigrants taking an interest in entrepreneurship during 2017, when Trump began to bring an end to deferred action for childhood arrivals and a court ruling limited the government to only being permitted to grant renewals but not new applications. Some young immigrants have been starting their own limited liability companies or freelance careers since the future of DACA remains uncertain.
If you are new to our channel, welcome and please subscribe to stay in the loop. We offer free 15-minute consultations if your case is qualified, so we can point you in the right direction. Stay tuned for the secret code later in the show.
The undocumented migrants that were sent to Martha's Vineyard by Florida Gov. Ron DeSantis filed a class action lawsuit on Tuesday against the governor. In the complaint, the migrants allege that they were provided misleading information promising cash assistance, employment opportunities, and housing assistance. There were nearly 50 Venezuelan migrants that boarded two planes which took them to Martha's Vineyard, yet they were told the planes would take them to Washington, D.C. and Boston. The migrants are being represented by Boston-based lawyers for civil rights, and allege they have suffered economic, emotional, and constitutional harms that amounts to a minimum of $75,000 in damages. The migrants are also asking the federal court to block DeSantis from doing this again. The D.C. Council has agreed to create a government office that will be used to offer support to the thousands of migrants that are being bused to the capital. The bill to create an Office of Migrant Services was written by Mayor Muriel E. Bowser. In the letter to the council members to approve the office, Bowser explained there has been roughly 9,400 people that have arrived in D.C. since April. The migrants have arrived on bus from Arizona and Texas, which she calls a humanitarian crisis. The emergency bill allows the Office of Migrant Services to provide the arriving asylum seekers with food, clothes, legal services, and shelters. The council voted 12-0 to approve the bill. The Department of Homeland Security announced publication of a final rule that restores asylum regulations consistent with the vacatur of the U.S. District Court for the District of Columbia in AsylumWorks et al. V. Mayorkas et al. The final rule is effective starting February 7, 2022. On February 7, 2022, the Federal District Court vacated the timeline repeal rule and broader asylum EAD rule, and effective February 8, USCIS stopped applying these rules to asylum applicants. USCIS is instead applying the provisions in place before the rules took effect in August 2020. This applies to Form I-589, application for asylum and withholding of removal. and Form I-765, application for employment authorization, pending with USCIS as of February 8, 2022 or received on or after that date.
Friends, show us some love and smash the like button. It doesn't cost you anything. If you have an immigration problem or need a second opinion because you cannot get a hold of your own lawyer, schedule a meeting with our team. Share information with our CARES team and they will help you get scheduled with our legal team. Now here's a secret code to unlock the free 15 minutes.